Yeah. She might be there. Sue Pritchard, Adam, I'm thinking is, I'm not sure who Adam is. So if you want to call it to order.
Attorney Glass, is that anyone from your team, Adam?
It's not my attorney.
I didn't think it was us, yeah.
I think it might be,
I think Adam was Adam Rose.
Stone.
Okay.
So you can open the meeting.
All right, officially call the meeting to open for zoning board of appeals, 7:01 PM. We could please stand for the pledge of allegiance.
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, the next meeting date is April 28th, 2026. Is there any conflict on the board?
Not on my end. Nope.
Yeah, sounds good.
What was that date again?
April 28th. Just a reminder, we have Sue here on Zoom, so all votes tonight will have to be a roll call vote. So I'm just gonna go right in order for the items on agenda because Marguerite's not here yet. To review, discuss, and act, 40B committee. We, as you guys know, we had a discussion back in January. Ralph, the town administrator, I had seen some correspondence from him talking about, wanted to talk to him about the thoughts of the 40B committee. His correspondence was great, but it was just confirming that he felt like we needed one. And then during our meeting, I realized that, well, the discussion that we need to have was about it being the necessity of it being a subcommittee. His initial correspondence did not address that, but that was my fault. I didn't really express that to him the first time that I was looking for him to speak on that. We have since gotten that discussion from him, and this is dated Wednesday, February 25th. It says, "Dear Chairman Karen, please accept this correspondence as a follow-up to my earlier email expressing support for reestablishing a 40B committee. As you consider this matter, I want to note that a 40B committee does not need to function as a subcommittee of the Zoning Board of Appeals. It can operate as its own independent body. It is my understanding that the previous 40B committee in Dayton was a standalone group, and if that has been the town tradition, I believe that a reestablished committee should remain separate from the zoning board." Thank you, Ralph. Obviously, that is not talking about us having a member of the zoning board being on the 40B committee, which we would do. We've already discussed that. It was more about what would the zoning board's role be going forward with the 40B committee. And now we have that talked about with Ralph.
I did have discussion, as I said I would, after our last meeting, when I met with Ralph on a number of things. That's one of the things that we talked about.
Yep.
So that was also, I think, that was part of the impetus, besides what you asked for him doing that letter. And the thought behind that was that if the board votes to have 40B as separate unto itself at this point, then what I would do is temporarily at least ask the Board of Selectmen to reconstitute the 40B committee with the intent of getting it back up and running and finding members who want to join it so that we can begin the business of the 40B committee again. My goal is not to be chair and not to be a permanent chair of it by any means. And I want to be clear about that. But my goal is to get it back up and running with the approval of the Board of Selectmen. And then once we can get it up and running and get members that we have enough members on it to step back, at least as the chair.
Okay.
So.
I mean, I don't think there is no vote needed on our part right now.
No, I didn't know if we voted. I forgot if we voted on anything related to it.
We didn't because we weren't sure if we were going to if it was going to operate as a subcommittee. So I don't want to make a vote on that. So as of this point, there's really nothing more to discuss until the selectmen have approved it being reinstated, and then you come before saying the zoning board now needs to have a member on it,
Exactly, that's exactly.
which will,
Yes.
I mean, we
Yeah.
can discuss that when
Yeah, when that time comes.
that time comes.
Yes.
I think it's a good idea.
All right, so then moving on to Stonegate Landing LLC, westerly side of Somerset Avenue, map 9. That's update of phase. My hope was that there would have been some discussion to have tonight, but we have, well, Kevin and I have, through our powers, told Richard that we need payment from him for him to talk about anything more he wants to talk about, and he has
So,
expressed that would not be go for it.
okay, so I spoke to him directly today. He stated that he would be dropping off a bank certified check tomorrow. And he has asked if we could have a workshop with the members that we've been having, Greg, Veronica, Marguerite, his team, to see if the proposal of a potential change or modification would be welcomed by the board. He originally wanted it with the entire board, but it's not during a regular meeting, and I told him that you can't do
Not
that,
happening.
that's an open meeting law violation. So he has requested or asked for that. I told him I would leave it in the board's hands. I said, but in any event, regardless, I said, none of that's gonna take place until we at least have that check.
Partial payment.
So, he said he will deliver that tomorrow, and I will inform the board immediately when that's received. I just need direction if you want to do the workshop or go straight to a meeting.
I mean,
Marguerite is on right now, so I don't know
Yes.
if you want to.
Yeah, I mean, I definitely will turn it over to Margaret and then to Greg, that's he's been the point person for this so far. Based on what I know he wants to talk about at the workshop, I'm not comfortable with that. I'm for the record, I'm comfortable with him having a workshop.
Yeah.
But what he wants to do with my position as chair, I've seen it.
Mhm.
That's not something to discuss at a workshop. It's
I think it was more just to meet the team players that he's trying to bring aboard.
I don't know. I don't know what function what use a workshop session would have for that. If he has a team, they know how to go about doing this. We don't have a workshop to talk about. Help me fix this. That's not what the workshop's for. And the more we utilize our resources, especially legal, that we don't get paid for, it's not happening. I'm not saying a workshop's not happening, but
Further discussion.
I mean, you know, I think, I don't know how much Greg knows now, but of what he's presenting for, that's a potentially a significant change.
Maybe,
That-
maybe.
That's, it's not being done at a workshop. I know why he wants the workshop, it's not happening. Unless Marguerite feels like we should do it that way, then we can discuss it, that's why I feel. Greg, how about you, based on what you're talking
No,
about?
exactly. I mean, I wouldn't even want to be discussing anything that I saw. Depending, unless we're in front of the entire board and let the board feel the same way I did when I saw it. And at that point, I agree. The only thing I thought Richard was trying to do is bring all the team players and talk about Phase A with the infrastructure. There is some paperwork in here that I was reading,
That can be
that
done,
kind of stuff like that.
that can be done, that's been done all along.
Yeah, he does have well, quote unquote, he has someone that he's supposed to finish Phase A for him. All right, I don't know if that's what we were gonna do, just meet the team players, feel them out, see what they're all about, then come in and I can tell you about the board, who each member is, what they are. I mean, I'm not opposed to doing a meeting, but if you don't want one, I understand I wouldn't be discussing any of that.
If the workshop happens, it's to discuss the completion or the continued work on Phase A.
Yes.
I don't want Phase B even mentioned. Because he's going to try to mention it. And basically from what have you seen what he's, okay, so.
Oh, yeah.
with what he's talking about doing, he, I almost say it's public, he does not want it to be done at a public meeting. That's why he wants to go before the board. So him doing it at a workshop is kind of a way around that. And I'm not saying that's what his intention is, but I don't want it to appear that way. I don't want it to end up being discussed. And then it turns out that's, what he wants to do. He can present at a board meeting, a public posted board meeting that the butters are notified of. Plain and simple. The workshops that can continue happening are to do what they were meant to do,
In phase A only.
to solve phase A's problems, not talk about a potential phase B. Unless it was him continuing it as he planned to do it, but that's not the case, that's why.
I think if he's looking for, and it sounds like part of what he's looking for is the release of lots and so forth as well. That's not something that would happen at a workshop anyway. That's something that we would have to vote on. And we would want to hear from Marguerite about that. We'd want to see, what, if he has a remedy for paying the balance of what he owes the account, and also potentially even for taxes and so forth.
Well,
So-
we can't talk about the tax.
Well, I understand that, but
I agree with you on that.
But I think there are too many variables. If, a workshop is going to be informational only. And what information can we glean from a workshop that we can't glean from if he has his team come at one of our regularly scheduled meetings? I don't think there's a difference.
Point of clarification, it sounds like, from what I understand, the quote unquote team of people he has are people that are going to be involved in phase B.
Except for one.
Okay.
Yep.
Okay, so that means that any team that he wants to bring and talk about,
Only for
it
phase.
better be for phase A only.
Yep. And of course,
That's the
that's
only one.
Yes, I know,
and
and
that's going to ultimately result in a
That's gonna be
request for
based on
release.
the other one being, you know what I'm saying? So I agree with you in a lot of ways.
And then just for the record, if you put, like he mentioned, Jeff Tardnico,
Yeah.
he put Dino Corp
Corp.
will be the contractor hired to complete phase A and site work on the 6 remaining lots.
Yes.
I don't know what kind of contract agreement, whatever you want to call it, he has officially on paper with any of these people. Not that it matters,
But
but
he's supposed to be with the way it was written, the only contract for full permitting.
right.
And in his, he also made note of Delphic Associates.
That's
Yeah,
that,
that's a totally,
Yeah,
that's
I-
gonna be phase B.
but and that, well, that's
Yeah,
even, I don't want to discuss
That's why I'm
that.
saying that.
I don't want to discuss that right now.
It shouldn't even be part of this right now.
No. Marguerite, what are your thoughts on, I guess, the workshop and the stuff that we talked about so far?
I mean, it's definitely the prerogative of the board, whether it wants to hold a workshop or not. I just want to make sure you understand that there's two elements with a workshop. First of all, they are posted meetings,
Right.
public meetings, so butters are always welcome to attend workshops if they want, or anyone else from the public. I wouldn't, if any board members wanted to attend, they would need to make sure that they weren't speaking and deliberating, but
Right.
But secondly, anything discussed at a workshop under the terms of the vote that you took for Greg to be the board's point person, he would need to bring back to the board. So nothing that ever got discussed at a workshop would ever be done without the public's knowledge. I'm also a little confused by your statement, Jonathan, that there was a request for a lot release. I didn't see that in the paperwork that I was sent
Me neither.
at
But
all.
I thought, I interpreted what he was
Okay.
asking for to
Okay.
be. Let me
Sure.
clarify.
He only has, I believe, 6 lots
Yes.
left to build in phase A.
Yes.
And so there would never be any lot release. There is no bond on that. There's no lots that are being held by the board, and that would need a release in order to complete that. He simply needs to address his outstanding debt and get the work done to complete phase A and
Well, I
request
think-
building permits for those lots.
Marguerite, I think what I meant by that is my reading of what he wrote was that he's hoping he doesn't have to make a complete payment in order for us to allow him to complete those lots.
My sense was that he was making some proposals about how to address the outstanding debt. He made proposals to the zoning board that address both the zoning board's outstanding debt and the the outstanding taxes owed on the property, which I have shared. And I think we've tried to message very clearly that this zoning board has no authority to
Right.
address. We do, however, we cannot act on future permit requests until he addresses that independently with the treasurer and collector. So as to whether or not this board wants to agree to some type of a payment plan of the outstanding debt, that would never be able to be agreed to at a workshop. That would have to become something that would be taken to the full board to confirm. The proposal would be to provide a payment upfront now, and then an additional payment at the time that he filed for potential project change involving Phase B. But again, it's a prerogative of the board to hold a workshop or not. I understand the board's concerns with expending additional resources when you have not had a good track record with him making payments on that. I also understand that really a workshop doesn't serve any purpose because, you know,
It did
he has one of
before.
two actions. He can come before the board and you put it continuously on the agenda and present this to the whole board in a public meeting, or he can act as he indicated he may be considering doing and file for a notice of project change. And at that point in time, he has also indicated that he won't dispute that it's a major change, and he would ask that it be scheduled immediately for a public hearing. So he can do that right now. He doesn't need to have the board's permission to do that.
Right.
And it isn't necessary that we hold a workshop. Perhaps if there's one or two questions that he actually has, you could just suggest that he contact Greg directly, Carrie, to ask those questions, and
That's
then we
fine.
would need a full workshop.
I don't, yeah, based on why the workshops were set up, they were necessary, well, not necessary, they were
Open to help.
thank you, they're beneficial. At this point, unless he's continuing the conversation that happened at the last one, which I don't know if that's the plan or not.
I mean, to be honest, I'm not sure there really is a need to do that. You know, I think that with Jeff Tardanico still, he was already presented as being involved in completing Phase A. The board's already had a meeting with him and discussed what needs to be done to complete Phase A. He's been provided with a Weston and Sampson report about what needs to be done to complete Phase A. He's indicated he would make some undertake some work out there on an interim and permanent basis. I think he's done some of that, but not all of it. I'm not sure there's a need for a workshop to review all of that again. But maybe, you know, when Richard speaks to Greg, he may decide otherwise. I think that if you want to give Greg permission to talk to Richard independently,
Absolutely.
and then have the authority, you know, once he's spoken to him, to decide if there's a need to have a further workshop about Phase A only, then that would make a lot of sense to me. And that you can just indicate that if he wants to have a conversation with the zoning board about his thoughts on Phase B, that he should do so at a full board meeting. And if he wants to talk about a payment plan with the board, he needs to present that at a full board meeting, or he comes in with the remaining monies owed and he doesn't have to worry about a payment plan.
Right.
Doesn't this all hinge on him coming in tomorrow with $5,000?
Yes.
I mean, if that doesn't happen, we're nowhere. We're
Correct.
exactly where we are now.
I was feeling the same way. That would be something, depending if he comes in tomorrow with the $5,000. And also, I don't know if this is being redundant, but this, in answering his question concerning the workshop, what if we asked him for, or maybe we have a specific outline of what he wants to discuss or ask at this workshop that he's requesting? Then that would give us our answer if he wants to involve B, or, you know what I mean?
I do know what you mean. Greg, in the past workshops that you gone into them to answer Sue's question, has there ever been an outline of what's discussed at the next workshop?
Yeah, so usually we go in and we're just he's like, same story, different page. We're just trying to get this Phase A wrapped up, doing the best I can. What we did on our workshop was he brought up his house in Easton, and that's one of the things that we talked about, possibly getting some money when that house was sold. put into the 53G account. We talked about the infrastructure and, we gotta bend a little bit. I'm like, well, that's something that I can't answer as a member. You have to go in front of the board. After reading some of his paperwork too, that we've gotten in the last, you can read between the lines what he's trying to do.
Yeah.
He's trying to cut some corners on the infrastructure of Phase A, because as Sampson and Weston and Sampson went out there, they found a lot of problems, more than he wanted to address. Like, if you're looking over here, come over here, look over here, you didn't want to hear it.
Hey, that's their job.
Those are the things that, he says he's gonna do these things, gonna get this, I'm gonna get somebody up there, clean up the street along the edge. We had to have the highway department go in, because he never did.
Mm-hmm.
And he said about, he's got this thing about the coming out onto 138 with all the cars coming in there.
Like a talking about
Yeah,
that.
it's just redundant. It's the same
Susan,
stuff.
it sounds like what you're asking is whether or not he could present an outline ahead of time or an agenda that says what he wants to talk about. Is that what you're asking?
Correct, yes. And then we decide it's concerning if there's a valid reason or to do this workshop or not. You know,
I do know what you mean. I think that I'm going to leave that up to Greg.
Like I say, I would meet with Richard if we're gonna talk about Phase A. If we're gonna get into Phase B obviously that's a whole different ballgame, and it needs, like you said, be in front of the board members and public input and all that stuff on that. I don't really think we should,
Do you feel like that a workshop is beneficial to that versus a regular public meeting?
I think if Kerry reaches out to Rich and says, look, if you plan on talking about Phase A only, and only Phase A, we will talk to you in that meeting. If you're
Okay.
trying to bring up Phase B, if Phase A can get done, if Phase B can get done, that's something that the board has to stand in front of, not me.
All right.
I would also add to that if he wants to get together with Greg to talk about Phase A, and it's just going to be Richard and Greg and not
No.
Jeff or anybody
no,
else.
It's Marguerite, myself, and Kerry.
Exactly, well, that's what I was.
And
Yes.
Veronica has been
Veronica,
involved?
she came.
Okay.
Yeah.
Yeah,
At this point, I don't know if there's a benefit to having Veronica be there. I'm not saying that there's a detriment to having her be there. I guess what I mean is I don't know if it's
If we're
necessary.
only talking about Phase A, then no, she doesn't need to be there.
That's what do you know what I mean?
Yeah.
I'm not saying I'm not making her feel excluded or feel like we don't need her. I'm not saying that. I just feel like based on what now is being discussed,
Unless-
hey, I don't really know what role he would have in that unless
Unless
Greg talks to Richard and Greg, you decide otherwise. I'll leave that up to you.
it could
Veronica
be,
was coming in to help sell Phase B. Am I right? That was what she was.
And potentially that
Find
possibly
a
included
developer to
who was willing to
take on
take on
B
Phase A,
and B.
right? But
So
I don't know. Well, we haven't gotten
the
crickets.
other side of this is that, and maybe,
John, where's it coming out of our mouths?
yeah, so
need to
we
wait.
need to understand that she was handling the stuff in Phase B. She had a potential buyer or developer to take on Phase A.
Right.
Those fell through. So at this point, if she doesn't have, unless she might have someone else, we don't know. If she doesn't have another developer, then there's no reason for Veronica to be there. If she does have possible developer to take on Phase B's infrastructure, Phase A's infrastructure and purchase Phase B the way it is,
Right,
then
and
that's something that, yeah, I agree, she should be there.
that's essentially why she was in the first place,
That's
because
right.
that's when they were there. She's like, "Let me help you figure all that out." It does not sound like that's being done, or something has changed.
I think everybody's seeing the cost of the infrastructure in Phase A.
I think so too.
And the taking on a Phase B
Especially-
board, what is said to be in Phase B at this point, no developer is seeing any money making. So at this point, it's a no-win. So that's what Veronica was there for. If we don't think we need Veronica, I don't know if it's a fee for her to come, if it isn't,
No, it's a state service.
it's not a problem. I have no problem having her there at all. I'm not saying that, but
Right.
it's just the principle of she was supposed to help help Richard find a developer to take on his project for him and finish it. And as the 2 or 3 potential developers have opt out.
Yeah.
My question is, and I'm going to actually sort of direct it to Marguerite, which is, if Richard has a contractor come in to complete phase A, for example, Jeff, does that change potentially the relationship that with 40B, even if it's still building the remaining 2 units, but if it's a different contractor doing that and finishing phase A, or subcontracted by Richard to do it, does that affect the 40B component at all for phase A? And could that mean that that's why Veronica needs to be involved?
So Jeff was actually the general contractor that the board had last approved for Stonegate Landing. So he's not somebody new.
Yeah, he's been around
Okay.
this whole project.
So having Jeff come in and complete the work on this is actually consistent with what's been approved by the board for this development. Both phases, as a matter of fact.
Thank you.
All right, Carrie, so I guess make that clear with Richard.
That we're definitely not doing a workshop, just straight to a meeting, as long as he makes the payment.
Unless Greg only feels like it's necessary. He's the one that's been at these workshops and having them. It's not right for me to say. The only reason why I'm saying I don't want them to happen is if he's going to talk about B.
Okay.
So if he's going to talk about A, not only if.
To be clear, let's
Yeah.
just be clear
Yep.
that it's, when we're talking about phase A.
Yeah.
We're not talking about really about the finishing of those other things. It's the actual infrastructure that.
Correct.
Am I right?
Yes.
So if any discussion outside of that is being planned,
Has to come in.
that needs to come
Mhm.
forward.
Absolutely.
Okay.
Well, the infrastructure in those 6 remaining houses in phase A.
And the 6.
Yes.
I know we have a cease and desist, so it's not that I don't think he could sell them. I just think right now, until he catches up with what the finances and all that stuff, which he owes us, then we can lift that and he could probably finish those 6 homes.
Correct. Which will only be through the conversation about payment of the outstanding fees, and that's something the board
Nothing
wants
else.
to discuss as a whole.
Yeah, I could talk to him about that stuff, nothing else.
So when you talk to him, if you talk to him, obviously I would say, let us all know as a board about the payment coming through, and then continue your discussions with Greg exclusively about the workshop.
Going forward.
And the assumption is he has to make his payment first.
Yes,
Everything bases off tomorrow.
everything
Or-
bases off its payment.
Oh yeah, right. If it ends up being Thursday, not tomorrow, that's whatever. It's not, I can't.
Neither here nor there.
Right. It's right.
If no payment shows up, then
We stay where we are.
Out of wasted breath.
That's that right, my friend. All right, moving on to item 3, Bruce LLC / Bruce Development Corp. Arborcrest Estates, Tremont Street, map 4, lots 54A, 55, and 77. The 3 sub items to discuss. The reason why I put this on our agenda today is because, as you all know, we all received a letter from Chief Nichols. I didn't want that, if it wasn't on the agenda, I didn't want it to come up under general discussion at the meeting without it being on the agenda, in case there are other parties that wanted to address it. And also because I've had at least 2 people from the public noticing that there's been activity back there, saying, what's going on? Are they starting? What are they doing? Nothing, just simple curiosity questions. I thought, well, if the public who are non-board members are noticing activity back there, I think it's something that we should discuss just to bring everybody up to speed on it. So obviously the first thing on it is the correspondence from the police chief. Carrie, which page is that in the packet? I mean, I haven't seen it obviously, but
should be right.
Yeah, 2nd page, 3rd page on Bruce LLC. Right there, it's the police talking about
okay. All right, so this was dated, January 23rd, 2026. It's regarding Green Acres Realty Trust 0 and 707 Chase Street, Dayton, Mass. Regarding the no trespass demand letter in satisfaction of MGL C 226, Section 120. Dear Mr. Gates, we represent Ruth Sear, owner of land in Dayton, Massachusetts, off Chase Street, known and numbered as Chase Street, parcel 004.000840050, and 707 Chase Street, parcel number 004.0003000.0, together the quote-unquote Green Acres property, end quote. Yesterday, January 21st, 2026, your attorney Joshua Glass and your agents trespassed onto the Green Acres property without permission. That unlawful trespass was witnessed by Ruth Sear and her husband, Robert Saville, and memorialized in the numerous pictures and videos which show wanton and reckless destruction of the Sear property. According to the Dayton police officer called to the scene, there was a claim that your employees and agents have permission to access the Green Acres property from a permit issued by the town of Dayton. That claim is false, as confirmed by the Dayton's Town Council. The comprehensive permit issued in 2003, if it remains valid 23 years if it even remains valid 23 years later, does not and cannot grant you any rights to access private property owned by Ruth Sear. We have a certified opinion of title to this land from an attorney licensed to certify title in Commonwealth GL Chapter 3, Section 70. That certification attests there are no valid easements or other rights of way that encumber the Green Acres property. What you claim to be quote unquote Chase Street extension, end quote, is not shown on the Dayton Assessor's records or in Mass GIS mapping. I sent you a written notice over 2 years ago that if you have an adverse claim, to please have your attorney contact me. No response was ever made to the notice served on November 20th, 2023, and a copy of which enclosed along with a return signature acknowledging your receipt. And it says this is a second legal notice pursuant to GL Chapter 226, Section 120, that you, as well as your agents, contractors, and employees, are forbidden to enter the Green Acres property as shown on the attached plan. That's the second page, sorry. Should you or anyone else enter these premises, you'll be subject to arrest and to a fine or both. A copy of this letter is being forwarded to the Dayton Police Department. Please immediately discontinue your unlawful trespass and misguided efforts to evade the proper process for resolving legal disputes. Very truly yours, Dennis Murphy. And then the enclosure was the Dayton Police Department. We have Marguerite here, and we also have Attorney Glass. Marguerite, do you want to speak on this first, and then I'll turn it over to the public?
It might actually be more helpful to have Attorney Glass provide an update because he was
right
involved and
Yep.
actually there, and I'm speculating more, repeating things third hand. So
Yep, okay.
why don't I defer to him first?
Just for the record, the other sub items are Conservation Commission status update and overall update of the project. Those are the other 3 items on the agenda that we'll be discussing tonight for this.
Do you want to just sit and present? Would you like me to stand and present? What works best for Zoom?
Be fine.
Okay, so if it's okay with the board, I'll sort of respond to the 3 agenda items, a bit of an update. I'll share with you the butter in question is also here.
Yep.
Obviously. So quick summary, we've been working on the definitive plan set, which we discussed last time we were before you, that we need to provide. We did speak with Weston and Sampson after the last time we were with you based upon the recommendation. We understand they'll be reviewing the definitive plans.
Yeah.
On the construction side, we're continuing the monitoring and the reporting with DEP and Natural Heritage. The wetland application report was provided at the end of the last growth season. Copies of that were sent to the Conservation Commission. I did see in your packet the correspondence that confirms the tolling, the actual of the DEP permits, the water quality certificate for it. Those are actually effectively vested through project commencement. But what you actually see there is, I think it's called the Permit Extension Act, automatically tolled permits without any need for a request by an applicant. So it's just a confirmatory letter that confirms that those permits legally extend to 2028, notwithstanding the commencement. So it's sort of adult matters. We're out there regularly monitoring for any erosion, silt control, everything is functioning properly, maintaining fencing. You'll see at the larger area, the fencing is up and maintained. At the smaller area, it's not. That's because it was deemed by the biologists and engineers not worthy to attempt to maintain that, but the stakes are still there. It's easier to put that silt fencing back up when the construction of those individual lots moves forward, but the silt fencing on the larger parcel, if you go by, you'll see is generally been maintained.
Okay.
And one issue, just for your background, that has come, not issue, one comment that's been brought to our attention by a few members of the public that may come to your attention, that may or may not have come to your attention. When you drive by the site, and you look to the easterly side of the access off Tremont Street, you'll see what people, I think, assume to be a detention basin that holds water. That is actually by the permit, by the approved plan, a pocket wetland. So
Okay.
that's why you see, and if you've had people ask, and people have asked us, why is there water there? Well, it's by design.
Yes.
So that has come up a couple times, and I just wanted to mention to you, that's actually right on the plan, pocket wetland.
Okay.
So that's what I would call a sort of summary Concom update, if you will. Relevant to that is a portion of what you have before you. So we were getting to the stage in the process where, as you may recall, the utilities for this project have to come through the Chase Street extension. And so as part of that, we had to engage with the Chase Street extension. The conditions, which we talked a little bit last time, but I'll flag just for the board, and Marguerite and I have talked about them a little bit. So condition 45 designates the Chase Street extension as the area for the underground utilities. Condition 47 says, as part of the definitive plan set, we need to provide an easement plan and easements for that area. Those easements are then eventually deeded to the town so that it can come in and maintain the utilities. And so our use of that area has been in conjunction with our deeded rights. We have never claimed once, notwithstanding the letter, what is said in that letter, that our being out there is based upon the issuance of the permit. It's our deeded right to locate utilities in that area. The permit says we need to put them there, and if we're gonna put them somewhere else, we have to come back to you. So we were reaching the point where we wanted to do and needed to do some surveying work out there, staking the area, confirming the boundaries, and we're gonna have to do some engineering and test pits, and we wanted to commence that work. So what you are seeing is the natural progression of that. You have, I think, 2 letters in front of you. There's been a lot more communication back and forth on this. So the neighbors, stepping back, and it is a private property matter, but it's obviously in front of you and it's been a little noisy. So I'll give you a little bit of that background without hopefully having it turn into an unnecessary back and forth, if you will. When we were last before you, the Sears came and spoke. We didn't hear from them after that. We sent them a note as a courtesy that we would be out there to do this work that you've been hearing about over the course of the last few months. Again, surveying, staking, test pits, and utility-related work and evaluation, which is the scope of permitting in that area. We made sure to communicate with the Dayton Police Department before we went out, mostly because we didn't want a miscommunication and we saw they had been sent letters. So we spoke with them, we met with them, they acknowledged that this is a private civil matter. And we went and actually knocked on the Sears doors the day we were out there and knocked on the neighbor's door, so everyone knew. And we're out there with the survey team. I candidly won't bore you with all the back and forth because I think it is a private property dispute.
It is.
I would tell you, for what it's worth, that it has created issues and problems. I mean, they've tried to physically block the access with walls. I would say that there has been a fairly large amount of verbal harassment of our team and team members. It's been pretty inappropriate. That doesn't frankly matter to you necessarily, but it has made progressing with that particular piece a little bit more challenging than I think is necessary. It is certainly, I'll stop it there. I would say the critical point is, at the end of the day, the Sears have a very easy and obvious path. A judge told them to file something if they had it, if they believed that they had these rights. We have told them to file something if they have these rights. There have been letters back and forth about this, say, you have these rights, you file something, and they have not. I don't know why. If they thought they had the right, if rights they claimed, presumably they would have filed something and they haven't. But at this point, we are trying to press it forward. We will continue trying to press that forward. It has obviously been a challenge. We have called their attorney. He has not called us back. Nevertheless, you know, we will keep an open line of communication with the Dayton Police Department when we go out there, so that there's no surprises. Or knock on the neighbors' doors when we're going out there. I don't know if the Sears appreciate us knocking on their doors each time we go out there, so we probably won't do that each time unless someone tells me something different. We will be going back out there now that the snow has begun to clear to finish the staking and do the necessary work that we had commenced. And all that being said, and again, not that it matters to this board, but just so you understand, there is an open line of communication available for most of the Sears if they want to discuss a resolution here or something amicable to move past this. So that is the sort of not so abbreviated summary. As I shared with Marguerite, we have not included this forward and all the back and forth
No,
correspondence.
right, I mean,
because
it's not, right, yeah,
it's probably not a good use of your time. But nothing has been filed.
okay. Just out of curiosity, so the letter from the police chief, was that before you corresponded with the police?
So
I guess I was wondering, like, why did the police issue that if you had already contacted them?
that letter is not from the police. So just so you know,
Right, no, I knew that letter was, yeah.
yeah, so I assume, I would be assuming, we met with the police before we went on site. We were on site and, I think this letter confirms on the 21st. The letter you have in front of you is actually the letter that their attorney sent after that. I think,
23rd.
I'm not entirely sure why they sent that letter again the way they did.
Okay.
There would be speculation involved with that, to be candid with you. But we did speak with the police before we went out.
That's what I was saying.
And I actually, after seeing this agenda, I went and spoke with the police again, just to make sure there wasn't something else
Right,
that we
okay.
had missed or we were unaware of. Because we know it's something that they've been attentive to as well. I think that each time we've gone out there, the Sears have called the police. And it's, I think, part of their job and we respect that. But
It is.
we also have, want to make sure that if there's information they need from us, we provide it. So the best information we can provide them right now is notice, which we'll continue to do.
Okay, and how about the correspondence with with Concom?
So the correspondence with Concom has effectively been them getting copied on the communications with DEP related to the wetland replication reporting and probably the permit communication that you have in there.
Okay,
There hasn't been anything substantive going on with Concom.
it was more just my own question. Yeah, I know it's Concom report, not ours. It's more just curious about it. Okay, Marguerite, do you have any feedback before I turn it over to the public?
Just a quick question, Attorney Glass. You mentioned that you were still working with Natural Heritage.
We
You
just had
said
to
it
provide.
quickly and I wasn't able to fully hear you. So can you just repeat what you said about Natural Heritage?
So Natural Heritage was, it goes back to the prior conversations. Natural Heritage gave us an approval, that I think they either called phase 1 or phase A for this, and we had to just keep them up to date when we completed the construction previously. We did that. The wetland replication reporting that we're submitting now actually goes to DEP. So it was more of an update since the last time that we were in front of this board.
Okay. So are you done with the phase 1 aspect of Natural Heritage or are you just still providing reporting?
I would have to go back and see exactly what the details were. I think we may have had another reporting piece where we go with them at the end of the growing season with DEP. But the next piece of Natural Heritage will relate to the definitive plan set.
Okay. I seem to recall, but I haven't looked at it in a little while, that their Natural Heritage still hadn't finished its approval of all of the phases. Is that right?
Correct. They broke it up into 2 phases. Their next phase is, again, what do they call it? I think they called it phase 2 or phase B was the larger footprint.
And you'll still need approval from them prior to that actually occurring?
They'll have to issue an approval, or I candidly can't remember if it was we have submissions that we need to make and then it will be permitted, or if there was still a discretionary component to it. I think they generally identified the requirements. But But again, it's somewhat driven by the definitive plan.
Okay. Thank you. That was what I was trying to recall.
Anything else, Marguerite?
No, nothing else.
Board members, Greg, anything?
No, not this time.
John,
Not yet, thank you.
Sue?
You might have to say.
Sue, and do you have any feedback?
Sorry, I couldn't unmute myself.
That's fine.
Yes, no, I'm all set.
Dave,
I'm all good.
please.
Oh, I'm all set.
All right, anything you want to share?
Yeah, so I'm Ruth Sayre, obviously it's Sayre, by the way. And I'd like to be clear, because there are a whole lot of things going on here, and I don't think we've had a fair presentation by Attorney Claus of what's been happening, but I will try to address them. And first and foremost, like, yes, I saw in previous minutes, yes, I inherited the house from my father, but I am in fact J.P. Mills's great-granddaughter. That's my family house, so I know the history of that house, and I know the history of the land and the right-of-ways and all these things, which there have been assumptions about made on that property. And I have the affidavit from the attorney. So let's track through this, because there are a bunch going on here and it got sort of out of timeline. The permit was granted by this board for this project, Arborcrest, in whatever year it was. And they could, almost 25 years ago. My daughter was tiny, she's an adult. And the idea was that the only way if the permit was valid was if they brought utilities and water, I forget exactly what, across my property. It's my property. This is not, in fact, a contested issue, despite their contesting it, right? They claimed that an old paper road that is not a right-of-way is a right-of-way. It isn't. It's a right-of-way to my property that's adjacent to my property. It is not a right-of-way to their property, which fronts on Tremont Street. So that's the reality. But this permit was granted on the assumption that they could dig their way through my forest. And there was subsequently, I think it's 2019, our suit, my family's, against the board saying you shouldn't have permitted that. And the decision that came down basically said, well, we can't undo what they permitted, but you have a valid argument for trespass. Now, I believe this is what Attorney Claus is referencing, that I am supposed to prove that he is trespassing. But that's not really the case. He is supposed to prove that he is not trespassing. And we had at the time a decision, which I'm pretty sure that Marguerite has, the claim on why that is not a valid right-of-way. We haven't. Okay. So we come to a more recent time, and I get, after that meeting, again, the time was wrong. After the last meeting, when I actually was here, my husband was with me, and we first talked about this. It was after that meeting that my new attorney, Dennis, not my previous attorney, who had been attorney for years and years.
Yep.
He sent the first letter that said, no trespass. That letter was presented to the police, well, so that was more than 2 years ago now. More than 2 years ago, we sent that letter to Dighton Industries, etc. And I get no response. 2 years. This fall, I get a letter from Dighton Industries, not from the attorneys, but from Dave, telling me that, first of all, it was kind of insulting and it called me, inappropriate for having my lawyer send them a letter telling them not to trespass. But anyway, that was the claim, that no, we can still trespass and we're going to trespass. And we say, no, you're not going to trespass. And I talk to my attorney, and my attorney tells me to put up a barricade. And it's actually well within my property. It's not even on the border of my property. And a lot of no trespassing signs, which, by the way, my neighbors are very upset about. But since that seemed to be the only way that I could stop people from coming on my property. So I send that letter along with the Dighton Industries letter to the police. And the police say, but it wasn't served by the sheriff. So it doesn't matter. I would also add that, okay, so I call the police and I tell them this is gonna happen, and I submit the documents to them. And they say, okay, well, call us when they come. And I do wanna point out, and I called the police again and told them this was unacceptable, that when I did call them, they didn't even come to my house and talk to me. They only spoke with Attorney Glass, who made whatever claims he made, I don't know, I would be assuming. Because I don't know, I wasn't there and they never came and talked to me.
Meaning the police didn't.
The police did, right. So I go out and I film while these guys trespass on my land, which is clear trespass. I know that they claim it's not a trespass, but it is. Like, I don't know how else to tell you. I have the legal documentation saying it's a trespass. They have not proven, they have never shown that they have legal access to my property. And they went out there, and they didn't do a ton of damage, but they were out there, and I did yell at them, and I told them to leave because it's my property. And so I very much don't appreciate being called unnecessarily rude. I mean, it's my property, don't trespass. You don't have that right. Just because a permit was given based on inaccurate information, that's not my fault. It's not your fault. You didn't do it at the time. We now know that that's where we are. And it, so this is distressing. So then the next letter is sent immediately after Attorney Glass and the survey team have been out there traipsing around and there again a second time. I mean, it's simply not their property. It is up to them to prove that it's their property. They have not proven it. And they are not supposed to be able to go ahead with this project without that access, without re-permitting. So I don't really know where that leaves us. I mean, I'm not going to suggest the answer, but it's not my job to prove when I have proved it already. And it was even mentioned in a court case that we had a claim for trespass by the Superior Court, right? So, like, this is just a sort of fishing expedition to figure out how much Dayton Industries, et cetera, can get away with. As far as I'm concerned, that's what's happening.
That legal documents that you have now, has that been submitted to the board?
I believe, I don't know, Marguerite, do you know if you have the Galvin decision thing, the Galvin claim?
I've been copied and I've been involved in all of the court cases, so I have all decisions. I'd have to go back and reread the one that I think you're talking about, but my memory of it is that the court indicated that you may have a private civil action related to a trespass claim, but that would mean you'd have to file it and determine, another court, a different judge would have to determine whether or not it's viable. I think from the board's perspective, what we don't understand is why there hasn't been ongoing communication besides letters. Whether it's through you or your attorney, it doesn't matter, but we just feel like this has been an issue and a dispute that we've known about since the permit was first applied for. And if there is a legitimate legal claim that exists on the part of either one of you, it's a private matter that should be resolved through a court if it can't be resolved amicably yourselves. And someone's going to have to bring that lawsuit, or as the board indicated in its permit conditions, come up with a different plan to bring utilities into the development other than what's been proposed.
So just for my understanding, like, until recently, one could not bring a case for preventative trespass. I understand that in the past year or so, that became possible in Massachusetts. But up until then, that wasn't a thing. At least like Dennis has been very clear about that with me, that you couldn't do it. You didn't go and say,
They might do it. You have to wait till they did it.
right, and so they've done it, right? And the problem I'm having here is the claim that there's no communication. Well, they were told 2 years ago not to trespass. They were told not to. I got no response until just a few months ago with a claim that they were going to trespass. And then I said, no, don't trespass. It's my property. like, I'm not sure how I'm supposed to respond other than to call the police. But the police were like, no, it hadn't been sent by but now it
Yeah.
has. Now it has been sent in the way that the police required it to be sent. So I will call the police again, and we can all say it's a civil matter, but you know, you've got a permit based on a problematic civil matter. I just am not, I don't understand. It's basically like telling me, oh, well, that's 22, they can just come through because we gave them a permit, which is actually what the police said they were told. And that is why it's in the letter. The police said that to us, that they were told that because there was a permit, they could trespass. Now, maybe that is not what Attorney Glass said. I hope not. But that is what the police told me. That is why it's in the letter. So, I mean, I'm very stuck here. It's my family property. People are tearing it up. They're gonna cut down a massive amount of my forest, which clearly isn't a right of way because it's a forest with like wetlands in it. So I don't understand why we can't figure out some other way than saying it's a civil. That's all I can, you know, and I can try to get you whatever documentation you need. Dennis was at another meeting or he would have been on the call. But like, you know, being told tonight that they're coming back, you know, that's a problem.
What's the most recent legal documents that you have?
Just the one that you have,
Okay,
although Gowan's in the process of registering the deed, so there's that.
okay.
Can I just ask, out of curiosity, in the original, way back when document of 2003 or 4,
Mm-hmm.
when that permit was issued, was there any kind of, do you have any record of any kind of stipulation?
Stipulation is that they can do the entire arbor crest if they access the utilities off of Chase Street Extension, which by the way is a tiny bit of road, is not what they're claiming, it just goes up the front of Jefferson Pike. And it's a private road, he paves that road, it's not even a public road, okay, let's be really clear on that. It's just a little bit of road, he paves it, he plows it. That, the claim was, oh, okay, so the permit happened whenever it happened.
Or was the original permit, I guess what I'm asking is, was the original permit that was granted approved with any conditions attached?
The condition in that, was that if they didn't come in that way, then they would have to get a new permit.
Right.
That was the condition. Yep, and so if they can't come in that way, which as far as I'm concerned, they can't, then they have to get a new permit.
Ask you a question. Why has your attorney not answered? Has he answered?
As far as I understand, he has been answering. I don't think that he doesn't answer is correct.
Okay.
I'm not gonna.
You can have your opinion on things. I called your attorney, he hasn't called me back. Both sides just sent letters. I'm not gonna get in front of the board, but there has been lots of communication back and forth, just so you know.
Okay.
I'm a little confused with this. I was under the understanding that this went as far as the Superior Court, Land Court, and it was ruled that there was an easement for utilities to go through the property when your father was alive. Do we have that documentation or is that false?
Don't know that it was.
That's not what the decision was.
No.
The decision was that they could rescind the board's decision on the permit. And they said, we cannot say that you're gonna rescind the
I
permit.
got you. I just wanted some clarification on it.
Yeah.
That was definitely it. It's a superior court.
In a nuance of that case, I believe what the judge actually said is, if you want to pursue a claim for trespass, that is a separate matter that you need to pursue, and they have not.
That she has now, right?
She has not.
And I couldn't before because you couldn't.
Until it happened.
And now they trespass. So the claim that I needed to proactively somehow go out and stop someone from doing something that they weren't supposed to do is, I think, a little disingenuous. on the part of council.
Again, that was actually what the court said. I'm not giving a legal opinion on this matter, other than to say nobody has filed any claims against us related to this matter. The court brought it up. We've told them they're welcome to. It hasn't been done. We can speculate as to why, but
I would actually be curious why the Dayton Industries has not proactively proved their right to access, because we do not have that documentation. There is no documentation in front of the board or anyone else. There is a constant claim that Dayton Industries has title insurance, and because you have title insurance, you have this access. This is it's a paper road that suddenly appeared in a deed in like 1959 that had never been there before. And it's not even a definitive line. Look, I'm trained as a landscape architect. I can read a map. The thing, it's like a random, I own 2 pieces of property that have a property line. And the claim is that somehow my property line is a right of way. It's simply not. And I don't know how I was supposed to get, again, like I said, in front of this before, because I was told I couldn't, right? It was, you gotta wait until they do
Until it
it.
happens.
And they did it, and here I am. And then it's very catch-22 for me, because the police are saying, well, we can't come because it's a civil matter, and you guys have said it's a civil matter. So, like, you know, I'm a property owner in Dayton, have been for 100 years, like my family. So what do I do? Like, this is why I'm here. What do we do? I'm not just gonna let it go away.
Marguerite, what do you suggest in terms of that?
I mean, I appreciate the comments from both you, Ms. Sierra, and Attorney Glass, and you know, it provides more context to the board that we weren't fully aware of. But
A lot more.
I go back to the fact that this is a private dispute that needs to be worked out. That's not really something that this board has any control over. It sounds to me, based on what I'm hearing, that there may very well be either communication amicably between the two of you to reach a resolution in the very near future, or some type of legal claim brought, because now the actions that one or both of you feel need to have occurred in order to bring that claim have occurred. And you know, the board certainly appreciates it if you want to keep us informed on that, but we wouldn't be a party to that action. So we wouldn't know the outcome of it until someone shares that with us. The bottom line is that the comprehensive permit indicates that if it is not possible to bring utilities through the Chase Street extension area as depicted on the plan, there will need to be a permit modification request presented to the board to bring in utilities in a different way to this development, and that would be deemed a major change. It's already been established in the comprehensive permit, and that would be subject to a public hearing process. But you know, it does seem like this needs to get resolved. I hear and understand your explanation, Ms. Sierra, about why it hasn't been able to be resolved in a court in this way yet. But it sounds like perhaps you're at that point where you can do that if needed. Maybe there's a way to reach an amicable resolution without extensive litigation. And hopefully you guys can at least attempt to do that initially. But that's, again, a private matter between the two of you that is not something this board really has any involvement in.
Great, board, any more questions?
I just wanted, so to be clear, the Chase Street extension for the utilities, I was under the impression that when that was all going down, that was already nullified. That's all it was going to be, is for utility use only.
Yeah.
And that was approved at Superior Court.
No.
So there were a couple of different pieces of litigation that the board has been involved in over the years. One was a butter appeal brought by Dr. Sear to the original comprehensive permit that was issued. And then there was also some litigation brought on the part of the developer when the board ultimately denied I was subsequent, I think it was the 6th extension request. And I think Dr. Sear attempted to intervene in that, and I don't recall if he was allowed to do so or not. The appeal of this multiple extension request was upheld. The developer prevailed, and it was actually determined that the initial extension was all that was necessary, and that one is valid and can continue forward. And so the board didn't actually have any authority to even be considering an extension beyond the initial extension. Dr. Sears' appeal, if I remember correctly, was addressed through a standing argument, and ultimately, I believe, through motions before the court. There wasn't a trial on this, but there was motions before the court. Ultimately, they determined that Dr. Sear didn't have standing to object to the appeal or to object to the permit. And even though there were arguments made within that summary judgment claim related to Dr. Sear's ownership rights in the Chase Street Extension area, the final determination by the court was what we kind of talked about earlier tonight, that to the extent those ownership right claims exist, they need to be pursued through a private action between the developer and Dr. Sear, and not as part of a 40B appeal. And so that determination by the Superior Court was appealed and upheld by the appeals court. And then I think there may have been a notice of appeal filed with the Supreme Judicial Court that was ultimately withdrawn. I was under the misimpression that there may have been a resolution at that time privately between Dighton Industries and the Sear family, but I have since been informed by Attorney Glass that that never happened. So, and I'm sure Ms. Sear, you can probably confirm that's the case as well. That was my misunderstanding. I had just assumed that was why it was withdrawn. No one had ever shared that with me. Again, these are private disputes, so it's really not within the board's purview to know about it unless someone wants to share that with us. But that's the litigation that happened, and that's where this matter has kind of been pending under sort of an abutter appeal, which actually was the longest action. That was the one that was resolved the most recently, as well as the appeal by the developer on the multiple extensions that ultimately one of them was not granted by the board.
Yeah, and just as a point of clarification for the board members, I posted this request to put this on the agenda for us to discuss. They did not ask to come before us. I did not. They didn't say we have things to go over with you. They didn't, and I didn't say we want you here to talk about this. I posted it because I felt like we needed to discuss it we should discuss it publicly. And then when Attorney Glass was made aware of it, he was like, "Oh, so this is on the agenda. You know, I have things that I can add." And I was like, "Sure." It wasn't like I didn't intentionally tell me, we didn't want him here. It's just, do you think, well, since it's on the agenda, do you want me to come and talk about it? I said that would be very helpful for you to come and talk about it. It wasn't like, that's the only reason why it came up on the agenda.
Okay.
Ms. Sarah, and I know we can't get into mediating this dispute. And I'm hearing our counsel say that this would be a matter for the courts, potentially. But I'm just curious, do you have, or have you ever proposed a solution to Mr. Glass or to his client?
Yes, I did. At the point 10 years ago when people apparently thought something happened, I met with Attorney Glass and I proposed some broad sketches of potential solutions, which I want to point out, they asked for permission at that point to grass my property because they didn't actually claim that they could. They asked for permission, but that's neither here nor there anymore because we're here. And I proposed that, yes, I would let things across my property if they changed things on their end. And the response was, absolutely not, we're not going to change a single thing. And that was the conversation I had. And there has been no movement since then except the ongoing, what I find to be quite hostile relationship.
So is that a place, again, not for this meeting, not for us, but from where you left off from?
Absolutely.
Is that a place, I'm asking you and Mr. Glass, again, not for us, but is that a place for the two of you to sit down with your counsel and his client, in essence, and see if you can start from that point again and go forward? Or am I missing that neither of you are willing to do that?
I am unwilling to accept I was more than willing at the time to discuss changes to the plan.
And now,
As I said, I'm a landscape architect. And that's what we do. I'm not a landscape designer, I'm a landscape architect. I can do subdivisions. So the idea that, like, I don't see how that is even possible now because of where we are. So my attorney understands that if they would like to make a proposal to me, that we could do that. But at this point, I am beyond making a proposal because I did that.
On your end, you mean?
Yes. I'm not beyond. So just so you know, I'm willing to work with people, but that is not the conversation that ever happened.
Mr. Glass, your thoughts?
I would say that
Attorney Glassman.
the characterization of the prior conversations is probably subject to dispute. Everyone has our phone number, everyone has my phone number. We've said repeatedly, we're more than happy to try to find an amicable solution. We tried for years. We won't characterize, and I won't characterize each party's role in that, but my door is always open. Everyone has my number. We would love to work something out that doesn't involve court.
All right, all set.
Thank you very much for your time.
Thank you, Ben.
I wish we had a remedy for you guys, but unfortunately we don't.
Can you both stand up and hold hands?
Stop it. Sit down, please. All right,
Just trying to break
moving on to
break the ice a little bit.
item 4, 2025 annual report submitted by Carrie. The record, excuse me. In 2025, the Zoning Board of Appeals, ZBA, has held a total of 10 public meetings and received a total of 4 applications for variances and special permits during the year. Of those applications, 4 were approved and 1 was withdrawn. Following the 2025 Board of Selectmen appointments, the 6-member board organized as follows. Chairperson Zachary Perrin, Vice Chairperson Gregory Logan, Clerk Jonathan Gant, Member Susan Gray Pritchard, Member David Phillips, Member Elise Vincent. The Zoning Board of Appeals continues to offer information on the town's website at, and give the town address there, is available Monday, Tuesday, and Thursday, 7:30 a.m. to 4:30 p.m., and Wednesday, 7:30 to 5:30 p.m., and regularly meets on the 4th Tuesday of each month at 7 p.m. The public is always invited and encouraged to attend. Finally, the board thanks Margaret Mitchell, Esquire, all town departments, town residents, and all the interested parties who have attended our public hearings this year, who has given us input and allowed the ZBA to make well-informed decisions to effectively carry out our mission for the town of Dayton. Respectfully submitted, the Zoning Board of Appeals, and it lists our names as board members, and then finally Carrie Easterday as office manager. Are there any questions, comments, concerns, rebuttals, editorials? We don't need a motion to accept, right?
Sorry?
We don't need a motion to accept. I don't think you, no, I don't.
Because he's submitting
Yeah.
it for publication.
Item 5, correspondence. We have nothing that we haven't already talked about. 6, we have public input, which I will turn it over because I do see a member, Adam, who's been muted. If he's just someone who is here for information, that's of course more than fine. But I don't know if whoever Adam is has anything they want to share, ask. They're certainly entitled to do that now. All right, hearing none, seeing none, we can move on to the approval of meeting minutes, January 27th, 2026. Is there a motion on the floor to approve those meeting minutes?
So moved.
Is there a second?
I second it. Elise Vincent.
All in favor?
Aye.
Aye.
We gotta do by name.
Yeah, thank you, John.
Sorry.
Aye, David Phillips.
I, Elise Vincent.
Aye, Zachary Karen.
Hi, Gregory Logan.
Hi, Jonathan Gale.
Aye, Susan Pritchard.
Attorney Mitchell, do you have anything else you want to discuss while you're here?
I do not, thank you. And next meeting, just, I might have missed it at the beginning, is April 28th at 7 o'clock, is that right?
Correct.
Okay, thank you. Have a nice
Thanks for coming.
holiday. Yep.
Holiday, Easter. Jesus, wow. Oh, is there a motion to adjourn?
I'll second that, Mr. Chairman.
What?
Made a motion.
Hi, Gregory Logan.
Was there a
I
second?
said I seconded it.
Okay. Hi, Zachary Karen.
Hi, David Phillips.
I Spencer.
Jonathan Gale.
Hi, Susan Pritchard.
Okay.
Have a great evening.
Hasta la vista.
Bye.
Hi, Sue.
I see.
Bye.
Bye.